Good afternoon, everyone. Good afternoon, advocates from Nairobi. Good afternoon, advocates from across East Africa. Good morning for those that are in time zones that are early in the morning. Welcome to this second session of the East Africa Law Society and Nairobi branch training on digital forensics. Today, we're going to look at the digital forensic process. We have our presenter again, who did a very good job last time. He will talk about the process. I will not speak much today. I would like to welcome our Deputy President, Deputy Secretary General, and Young Lawyers Representative to the East Africa Law Society to make the opening remarks. She will then invite Chairman of the branch, Nairobi branch of the Law Society of Kenya, who will also open the session for us before we hear from the presenter. So, Madam DSG, karibu sana.
Good afternoon, members. Once again, thank you for taking time to tune into this session. This is the second part of our training on digital forensics for legal professionals. I believe last time the TLS Secretariat sent out the presentations, both the PowerPoint presentation and the recordings to everyone who registered and logged in. However, if you did not receive it, please drop your email on the chat section or the Q&A question section. I'll pick it and ensure that you all get the presentations. Last time, Mr. Dinga took us through digital evidence, the issue of admissibility of digital evidence in judicial proceedings in terms of authenticity, relevance, credibility, and integrity. Today we go into part 2, where he'll discuss the digital forensic process, common digital forensic practices, amongst other areas. Some housekeeping rules. If you have any questions, please drop them on the chat section or the Q&A section, or you can also raise your hand. We'll do, I assume the presentation will be for about 1.5 hours. So towards the last 30 minutes, we'll pick the questions and Mr. Dinga will attend to them as last time. Thank you for sending in your feedback. We received feedback from most of the members. We received the feedback and all of you stated that you enjoyed the presentation and you're looking forward to today's. So without further ado, allow me to welcome our chairman and my co-host, Mr. Eric Theuri, who will in turn welcome Mr. Dinga to this session. Thank you, enjoy the session.
Thank you so much, Barbara. Good afternoon, friends, ladies and gentlemen, fellow colleagues. We want to welcome you to part 2 of our joint series between the East African Law Society and the Nairobi branch on digital forensic. We are quite delighted that with this partnership and the response that you gave us on the first part for those of you who joined in. So we are actually looking forward to the next series on this presentation. Lawrence, you set the bar high with your first presentation. And so we are quite sure that you would be able to at least meet the standards that you have set for yourself. This is an exciting area because criminal justice procedures in civil trials will largely be informed by evidence that is discovered through the digital process. So in the civil world, you will have discoveries of digital evidence. In criminal, we are increasingly relying on digital evidence to convict, and nothing brings that case home than the evidence that came out during the Willy Kimani trial, and which from all indications is probably the key cornerstone of that trial. And so it is increasingly becoming clear that an advocate in the current age must have hands-on understanding of digital evidence, and we are quite delighted that we are having this opportunity to interact and get to understand this topic in a much in-depth manner as we have set out to do in part 1 and now currently in part 2. So in the interest of time, I would want to welcome Lawrence Dinga to give us his presentation. As my co-host Barbara has said, we will be taking questions towards the end of the presentation, perhaps within the next 1.5 hours. So you could put your question in the Q&A and in the chat section. Then as the presentation is going, and then we'll come back to those questions and get our presenter to also address those questions. So Lawrence, karibu, and we are looking forward to hearing from you.
Thank you, Mr. Chairman, for that introduction. Let me just share my screen first. Yeah, thank you, Mr. Chairman, for that introduction. And hello, everybody. Welcome to this 3-part webinar series on digital forensics for legal professionals. Today, we are looking at part 2 of the series. And what we are going to look at is digital forensics process. In this case, we are going to look at what is it when we talk about digital forensics. Last time we looked at digital evidence, but digital evidence comes out of a process of forensics, digital forensics process. So for those who were not there last time, I'll just introduce myself again. My name is Lawrence Dinga, and I'm a consultant in ICT. With a wealth of experience, over 20 years in consultancy in ICT. So I started doing ICT from those days when we had the MS-DOS going into network. So I really understand IT, the IT part of it. Now, after doing that, I've just found it was also necessary for me to look at the other side of ICT, because you find that ICT, as much as it is something which is good, something that is really into our lives. Some people are also using ICT for other nefarious means, motives. So I decided to look at the other side of ICT. How do you actually investigate things that have been done, crimes that have been committed using ICT? So at the same time, I'm a trainer, I'm a speaker in cybersecurity and digital forensics at an international level. And I'm also a consultant with the cybercrime program office of the Council of Europe. Normally what I do sessions on judicial training on cybercrime and electronic evidence, and also on law enforcement training on cybercrime and electronic evidence. Now, I'm also a cybersecurity and digital forensics expert, witness in court. So what I do is normally if you have any case that is involving cybercrime, we can do the investigation, and after doing that investigation, we'll be able to do a report, discuss the report with you, and if need be, I'll be able to go to court to give my testimony in the court, defending the report that I've done. Sometimes it happens that you are a defense lawyer. And in that case, what you do is that you've been served with a report by the prosecution. and the report involves digital evidence. So what you can do is that normally the court will always allow you to go and get an expert to look at the report and then counter the report. So that is something that I normally do. So I just look at the report, I look at the weaknesses on the reports, and then we try to work with you and to poke holes on the report. What happens is that what should be clear is that I'm not a lawyer in my profession. I'm not a lawyer by profession, but I work very closely with lawyers in terms of looking at the digital evidence. Now, my qualifications, I have MSc in Forensic Computing and Security from the University of Derby in England, and I'm also a certified information security professional. So I understand information security inside out, and that's why when it comes now to investigating things in cybersecurity, I'll be very good at that. And I also have some knowledge in law, having done a diploma in law from the Kenya School of Law, and I've also done LLM in ICT law from the Open University of Tanzania. So that is who I am in a nutshell. Now today, what we are going to look at, we are going to look at what digital forensics is. When we talk about digital forensics, what is it? We need to understand that. Then we are going to go and look at the digital forensics process. What are some of the process? What process you need to follow to make sure that the digital evidence that you are going to bring to court will stand the test of the court. Now, then within the process, we are going to look at what are some of the good practices and standards that an investigator can follow to make sure that, yes, they are really following internationally acceptable principles and practices in their work. Then we are going to look at admissibility challenges. Last time there were so many questions about admissibility. So we are going to look at the admissibility challenges. And when we are looking at that, we are going to look at that together with the Evidence Act. Then we are going to look at some case laws that are involving digital evidence and how they were resolved. Now, so when we talk about digital forensics, what is digital forensics? Now, by definition, digital forensics is a branch of forensic science. Forensic science is a discipline that has been there for long. So digital forensics is just a branch that was just came into practice just some few years ago. It is not a very old discipline. So it is a branch of forensic science that involves methodical application of computer investigation and analysis techniques to gather evidence found in computer and other storage media. So we need to understand here that it is a science. Digital forensics, it is a science. So whatever you're going to use, you are going to bring to court, it must have followed some scientific process, some scientific principles. So you use the scientific principle to investigate what has happened within a computer or any digital storage media. Now, it involves the use of modern technology tools and procedures to identify, preserve, recover, analyze, and present digital evidence in a manner that is legally admissible in court of law. Now, what you need to understand when we talk about forensics, first of all, forensics means bringing to court. Is a Latin word, which means bringing to court. Now, if you are doing investigation, what you need to understand is that this investigation that you are doing is going to land in court. And when it lands in court, you have to go there and maybe try to defend the investigation that you do. So as much as it is a science, it also has the procedures that you need to follow, so that you make sure that whatever you're bringing to court really conforms to what is laid in court, so that it is legally admissible. So what we can say is that digital forensics is actually the convergence of science and law, because you use scientific principles to do the investigation, which is then you apply, you bring that to court. Now, when you bring it to court, the court will determine whether the evidence that you brought to court is worthy evidence. Is it credible? Is it authentic? Those things that we looked last week about the characteristics of digital evidence. Now, when we talk about digital forensics, we are talking about branches, or we have branches or classification of digital forensics. Now, before it was just called computer forensics. But now, if we look at the diagram that I put on the screen there, you can see that in digital forensics, we have branches of digital forensics. We have the branch of computer forensics, we have the branch of mobile forensics, then we have network forensics. I can tell you that computer forensics is the oldest of these categories, because when this started, it was only computers that had got the evidence that we could be sought by the law enforcement. So that is why it is called, it is the oldest, and it is the most matured among these categories of digital forensics. In computer forensics now, you have different categories in computer forensics. We have what we call postmortem forensics. We have what we call live forensics, application forensics, and other devices. Now, when we talk about postmortem forensics, this is where you are using tools to acquire, to process, and analyze and report data that is stored on computer or any other digital device when that computer is off. It is not on. It is not turned on. The computer which is off. You go to somewhere and somebody just hands over his laptop to you. The laptop is not on, and then tells you that, please, I want you to do this investigation to find out what could be in that particular computer. Now, then there is what we call live forensics. Now, live forensics is also not very old, but it is picking up. Why is it picking up? Because sometimes you, as an investigator, you go to a place and you find that the devices or the computer that you need to investigate cannot be taken off the network, or cannot be carried to a laboratory for analysis, because maybe it is doing something which is very, very important. For example, if you go to a corporate organization and you find that the evidence is found on a server, and they're using that server for a lot of things, storing the other data. So you cannot pick that server and tell them that you are going to take that server for analysis. It will force you to get information or get the data from that live server. So that is what we call the live forensics. It is coming up very strong nowadays, and you find that most law enforcement investigators are faced with this problem. You go to a place and you cannot carry the server, and you have to do live forensics. Now, application forensics is where you analyze applications, things like the databases, to find information that is necessary for your investigation. Then we have other forensics, like we have things like DVR, we have things like game consoles, we have things like skimming device. These devices, what happens is that they have a storage. There are storage media which can be able to store information. So if you go and you go to a place and you find that they have a game console, and that could be the main suspect or device that they are using to store information. So you need to find out how you can get information out of these devices. Now, when we look at mobile forensics, it starts picked up, because you find, let me go back to computer forensics. When you look at computer forensics, you'll find that computer forensics, you'll be doing it on Linux operating system, you'll be doing it on Windows, and you'll be doing it on MacBooks, Macintosh computers. Now, when you talk about mobile forensics, it has come up very, very steadily, because you find that most people nowadays use mobile phones, and they store a lot of information on mobile phone, and the mobile phones is also used for some other nefarious motives. So it is a branch. We have a branch called mobile forensics that you just dedicated for doing analysis of mobile phones. Now, the process that you use the process and procedure that you use to analyze computers is quite different from the process and procedure that you use to analyze mobile phones. So in mobile phones, we have things like Android phones, we have iOS phones, we have Windows phones, we have many other, even Chinese phones. So how do you investigate? How do you find information out of this? Now, that is where we talk about mobile forensics. Now, the other category is called the network forensics. Network forensics is whereby now you go to a place and network is running, and you are able to capture packets we are canvassing the network and analyzing them to find what information they have. So that is what we call network forensics. It has got, we can do in live forensics, it can do captured packets, whereby after you capture the packets, then you will be able to analyze. Sometimes also we've heard about what we call malware. Malware is just a malicious software, things like viruses that will invade or invade your network. Now, in that case, what we do is we do malware analysis. It's part and parcel of forensics to find out how did this malware get into our network. So that is the classification. That's or categories of computer forensics or digital forensics when we're talking about digital forensics. So now, digital forensics investigation, what are the steps? First of all, you need to make sure that you obtain a legal authority to search and seize. I think we talked about that last week, that one of the admissibility criteria is when you bring something to court, then you must be sure that you had the legal authority to search and seize that particular evidence. So the first thing is that you need to get or obtain legal authorization to do that. Secondly, after doing that, you may secure that scene of the crime. Then after securing scene, document the chain of custody of every item that was seized. Now, this is very important for lawyers, because there are certain very little things that you might ignore, but they bring down your case. Because if you don't maintain this chain of custody, remember, chain of custody, we say that by the time you get into the scene, you need to make sure that you document each and everything on the scene, because just the same way as physical crime scene. So you need to document the chain of custody. Then you need to collect the evidence, or the pieces, the devices that are actually the suspect, you bag them, you tag them, and then you safely transport them to the laboratory. Now, why this is very important, because when, for example, you go and get a mobile phone, and the person knows that very well, that this thing has got incriminating evidence. So what they will do is to try even to delete that data in that particular device remotely. So that is why it is important to make sure that you tag them, you bag them in such a way that if it's a mobile phone, they will not be able to communicate to the external world. Now, then acquire evidence from the equipment using forensically sound methods and tools to create a forensic image of the evidence. We are going to look at that. Then design your strategy of e-evidence, including list of keywords and search terms. That number 6 can only be shown when we are doing it practically using any forensic software. Then you know how to get your keywords. Then you search those keywords for the type of evidence that you are looking on at in those devices. Now, then examine and analyze forensic images of the e-evidence, never the original, according to your strategy. So this is also, number 7 is very important, because do not interfere with the original evidence. Remember what we said when we were looking at the rules of evidence. We say that the best evidence is the original evidence, or a proper image of that evidence. So it is important not to interfere, not to analyze the original evidence. You'll always analyze what we call a copy of that evidence, and we are going to see how to acquire that copy. So it is important to know that you do not interfere with the original evidence, because sometimes you go to court and then the opposite side says that no, we do not want to rely on your report. We want the original evidence so that we can also do our investigation to find whether we are arriving at the same results. And remember also where the ACPO principles, principle number 3 is that you should be able to allow the other party to do audits to make sure that they can also get the same evidence results. Interpret and draw inferences based on the facts gathered from the e-evidence. Then you check your work. Then describe your analysis and findings in an easy to understand and clearly written report. Now, this is important because when you are making your report, you are making your report to judges, to magistrates, maybe to the prosecutors. These guys are custodian of your report. So you should not be technical, use technical language in that report. That report should be able to be done in an easy to understand and a clearly written manner so that they are able to understand. Remember, even when you go to court, you are there as an educator. Judges, magistrates, these guys are not digital forensic professionals. So they are good at their work, but you need to help them draw decisions from the report that you are going to give them. So it is important that your report is easy to understand and clearly written. Then give your testimony under oath or deposition or in a court, on a courtroom. That now depends on what maybe your client or why you are doing the investigation. But remember that anything that you are doing when it is digital forensics, remember that it will land in the court of law. It should land in the court of law. Now, let's look at the investigative process. Now, here I've given you this diagram. This diagram is ISO 27037. Now, if you look at the investigation processes or digital forensic process, many books will give you different steps or different phases. Now, that is why I've used the ISO 27037 is just a family of international standards that is trying to bring some sanity in terms of digital forensic process. Even though if you look at it, it only addresses a few issues on the process. It just addresses identification, collection, acquisition, and preservation. Is not looking at now how to analyze the digital evidence and how to present that digital evidence. But this is our basis of the digital forensics process that we are going to look at. Now, let's look at the first process, that is identification. Now, the process involving the search for or recognition and documentation of potential digital evidence. Here is where you are being called to a scene. And you as the expert, first of all, what you have to look at is you have to look at what is it that you need to investigate here. Because you might go to a place, you have a mobile phone, you have a desktop, you have a server there. You have so many things that are there. So the first step of identification is to know which digital devices that you need to investigate. Now, in this case, the investigator also learns what types of digital data and devices that might be involved in the investigation. Now, this step also allows the investigator to plan for tools and techniques to be used during the subsequent steps. Remember, when you go to a place and you find that there's a mobile phone and then there's a digital, there's a computer, desktop computer. Now, the process that you are going to use to analyze the mobile phone is not the same process that you are going to use to analyze the desktop. So that is why during the identification, it will help you to know which tools do I need, so that you can plan well and know which techniques to use in the subsequent steps. Now, it's also allow in the investigator not to avoid collection of unnecessary devices, because there's a times and some investigators went to a place, and what happened is that they found that these guys had got desktops, and instead of collecting the CPU or the main computer, these guys collected the monitors, because what they were doing that what they saw there was on the monitor was not, and they didn't know about the CPU. So it is important to make sure that you only collect what is necessary when you are doing investigation. So the first phase on digital forensic process is identification. Now, the second phase is now what we call the evidence collection. Now, during the evidence collection, this is the process of gathering items that contain potential evidence. Now, here we are talking about, you are going there, you see a computer is there, you pick the computer. You see a mobile phone is there, you pick the mobile phone. So you are gathering this so that you take them to the lab for analysis. So these devices are transported back to forensic lab or any other facilities for acquisition and analysis of digital evidence. Now, the investigator must have the legal authority. We've talked about that. Before you collect anything, you must have the legal authority, because if you don't have that, the things, what you are going to do in subsequent steps, you are going to be useless, because that evidence is not going to be admitted in the court of law. Evidence that is improperly collected, it cannot really be used in the court of law. So collection here is also based on what we call the value of the evidence and the volatility of the evidence. Now, if you go to a place when we talk, and you know that yes, this is what I'm looking for, and what you are looking for, maybe it could be on a desktop, and you go there and you find that the desktop is on. Now, when it is on, we talked about that nowadays many computers, or most of the computers, have got very huge memory. Now, if they have very huge memory and you don't collect that information, then that information will be lost when you down the computer. So it is important that you look at the order of volatility, and the information that is in the RAM should be collected first. Then you collect the other type of information. So where the device cannot be taken from the scene, like if you go, we've talked about the server, you need to do live acquisition so that you can collect the volatile and non-volatile data from the devices. Now, when you go there and you find that there's some illegal item in the plain view, then it is also reasonable to collect that evidence, because if you leave it, it might have very crucial evidence, and then it might be lost, or it must be hidden, it must be altered, it could be destroyed. So it is important to look at your collection scene and make sure that you are able to collect everything that is there. The scene should be, when you go there, you should be able to thoroughly search the scene. It should be done thoroughly and systematically, and make sure that you look at what is running on the computer. If the computer is running, look at what is running, because it could be that the suspect has initiated a process to delete maybe the information from the computer. So you have to be very, very careful to look at what is happening on the system to see if it's a destructive process going on. Then you just go and plug the power from the computer so that you preserve that is preserved through dump or whatever. Now, what happens here, I gave you an example in 2013. There was this drug lord. The guy was called Ross Ulbricht, but he used to call himself the Dread Pirate Roberts. He was the owner of the Silk Road. Silk Road was a site in the dark web, and it used to sell drugs. So this guy had made such a lot of money in terms of bitcoins. In fact, when he was arrested, his laptop had got around 28 million equivalent of US dollar in bitcoins. So what happened is that what I'm trying to bring here is that when this person was going to be arrested, the FBI had located this person, and they saw him entering a cafe. Three of this FBI. One of them was a lady, so they sent the lady to go and talk to him, distract him, and then while the other guys came and grabbed the laptop and then went with it. Why were they doing that? They didn't. They knew that when this laptop is shut down, that's the end of it. So that is why it is important when you go somewhere, you might be able to find a computer is on, and then when you put it off, you will not be able to put it on, because it has got some encryption with it. And encryption is what we call anti-forensics. It will be, when it is encrypted, it will be able to get data from there. You remember also there's a case between FBI and Apple, when they said, okay, they wanted the iPhone to be decrypted, but this guy said no, this is not what we can do. It was actually done by an Israeli company. So that is my point here, is that you have to be very careful as the investigator to know what is to look at what is running on the system, and if the system is on, please leave it on. Look at what is running on the system, and try to get information from the running system, from the RAM. Consider potential encryption. We've talked about which may be installed on the computer. And when you see, when the computer is on, mostly you find that most of the information is in RAM. So if there was an encryption, the hard disk is encrypted, the key that was used during the time the computer was booting is probably in the RAM. So it is important to see how do we do memory forensics to make sure that you can recover those keys, so that when you down the computer, it will, you'll be able to put it on again. Now, evaluate the impact of pulling versus shutting down the computer. We talked about that. If something is, you see that is maybe the data, there's a process which is wiping the data, pull the cable from the plug. You also make sure that you document, photograph, or sketch all the wires, so that when you go back to the lab, you'll be able to connect them. Package the evidence in a manner that will prevent it from being bent, scratched, or any way, or the data which can be deleted remotely. So leave the phones in their power state, how you found them. Do not actually put the phone down, because it might have a password and you might have a problem later on. So that is the collection phase of digital forensics. You must make sure that you follow the proper procedure to collect the evidence. Now, after that, you've collected the evidence, you know which evidence you need. Now you do what we call evidence acquisition. Now, evidence acquisition involves taking that particular computer, if it's a laptop, getting the hard disk out of it, and you do what we call disk imaging, which is actually duplicating the data so that you can be able to preserve the original evidence. So this process is done through disk imaging, which means that you are creating bit by bit copy of the content of the digital device. Remember when I said that when you delete a file, the file in a computer or in a hard disk, it is not actually deleted, except that the operating system marks that space as deleted. So when a new file comes in, the operating system will write in that particular space. And however, it could be that that space is the file that was in that space was smaller or was bigger. So when it was bigger, then the space that the file that is going to be written in that space, if it was smaller, then there's going to be some remnants of data from the original file. This is what we call a slack space. So when you're doing the normal copy and paste, what you're doing, you are not copying that everything in that hard disk, because those slack spaces or those remnants are not being copied. So that is why doing the disk imaging, make sure that each and everything in that computer, that hard disk, is copied, including the empty space, unallocated spaces, including the of files that were deleted. So that is what we call evidence acquisition. You duplicate the disk, the data, and this one you do it through what we call disk imaging. Now, this imaging, once it's done, it is always in form of a soft file that, or you can, if it is you are doing it on another hard disk, then you must have a similar hard disk with the ones that you are imaging, so that once it is done, then it has got the same content as the original. So when you do this, you use what we call write blocker, because you do not want actually you make sure that the data that you are duplicating is not written back to the hard disk. Now, the integrity must be maintained during this time, and when you are doing the examination, you only do the examination on the bitstream copy, the copy that you've done rather than doing the original. So you will preserve the original so that you can make any other copy, but you should make sure that you don't work on the original. Now, to verify whether the copy that you've made is similar in content and everything with the original, you do what we call a cryptographic hash. Hashing is just a mathematical a mathematical function that you run on the original hard disk, and then you also run the same mathematical function on the copy hard disk, and it produces what we call the message digest or hash value. Now, when you compare the hash value between the original and the copy, they should be matched. If they match, then you know that the original is this as the copy. So that is what we call cryptographic hash value calculated on both copies. Now, don't worry about this, because the software that you are going to use to do this will always calculate this hash value for you. Now, currently we use what we call the algorithms that are used for doing this is called there's one called MD5, message digest version 5. We have what we one called the SHA-1, which is the secure hash algorithm 1 and 2, and SHA-3. So those are the algorithms that you use when you want to preserve the integrity of the data that you collected, just to make sure that the original is equal to the copy. So when you are working on the copy, you know that everything that is on the copy is also on the original. Now that is the diagram that I put there. You can see we have the hard disk on the right, and then between the hard disk and the that is doing the acquisition, there is this black thing which is called the write protector. It is making sure that the hard disk is not you don't write what is not unnecessary on the hard disk. So that is what we call write protector. They can be hardware write protector, or they can be software write protector, depending on the tool that you're using to do your forensic analysis. Now, precautions should be taken to prevent exposure to evidence that may be contaminated with dangerous substances or hazardous materials. All items submitted for forensic examination must be inspected for their integrity, and methods for acquiring evidence should be forensically sound and verifiable. Any deviation must be documented. So when we talk about forensically sound, which means that the process that we've used can be verifiable, which means that I can take this thing and give it to a third party, then the third party will also do their investigation, and they will be able to come to arrive at the same results. So digital evidence submitted for examination should be maintained in such a way that the integrity of the data is preserved. Any errors encountered should be documented, because this documentation is very important when you go to court. Because if the court will be able to establish that there are some processes that were not properly followed, then they'll cast doubt on that on your digital evidence. So steps should be taken to ensure integrity of the data acquired. This may include one of the following: the hash value we talked about, MD5, SHA-1, and SHA-2. Then it should be stored properly. If it is on the media, it should be properly validated, and it should be sealed on a tamper-proof bag to the lab. Now, when we talk about acquisition, we've talked about the physical acquisition whereby your hardware and software write blocker should be used to, when possible, to prevent writing to the original evidence. Then you have the forensic images, which should be acquired using hardware and software that's capable of capturing bitstream image of the original media. What I've just shown you on the previous slide. Then we have the logical, where we also have now software write blockers, which you don't have that particular gadget or device. The write blocker is embedded on that software, and you'll be able to collect information using the tool. Live forensics, we've talked about where you go to a place, the server is there, and you can't pick it, so you'll be able to acquire evidence from the live server. So live acquisition software should be run from trusted media to prevent unnecessary changes to the live system. Now, you have to be very careful, because when you talk about live acquisition, there is going to be some changes in the status of the system, and the only thing is that you must be able to explain these changes, the changes when you go to court. So it is important to know that, yes, when I'm doing a live forensics, the possibility of introducing some data into the suspect system is there, but you need to know how to defend that in court. So documentation, once you've done that, you need to document. Documentation is very important here. You must make sure that the examiner name is put on is displayed, the acquisition date, the acquisition details, things like the type of acquisition that you did, whether it was for physical, whether it was logical, and the tool that you use. You have to, the version number you have to put the physical condition of the evidence and unique identifier, like the serial number, description, make, model. This information is important, because when you go to court, these are some things that you are going to rely. Remember the case, the case about Rasanga and Oduol. What did Justice Mchelule say? They needed the certificate for audit purposes. So this information, you must make sure that this information is available and can be verifiable. So after that, there's the preservation. The preservation process here. We are talking about the process to maintain and safeguard the integrity and or original condition of the potential digital evidence. You must make sure that, because you see, when you're coming to court, and the court will be able to ask a test, give you some test to find out whether the integrity of this evidence is maintained. So it is important that when you're preserving that evidence, from the time that you collect the evidence to the time that evidence is brought to court, and maybe the case might drag for years and years, but provided you maintain that evidence, that condition to convince the court that yes, this evidence has not changed. That is the aspect of preservation. You need to preserve the evidence properly, so that the court will be convinced that the evidence that we are dealing with, in terms of integrity, this evidence has got some good integrity and has not been interfered with. So make sure that also that the digital evidence is very preserved properly, because digital evidence is very fragile and can be easily altered, damaged, or destroyed by improper handling. Just the handling alone will make sure that evidence either admissible or inadmissible. So evidence preservation will help you assure the admissibility of that evidence in the court of law. So digital evidence should be stored under strict access controls to protect it from accidental or deliberate modification, as well as appropriate environment control. So this you must have an evidence room, maybe if you have a laboratory, and this evidence room must be properly protected. You must make sure that the evidence that is going to that room is logged, proper log is maintained, and if evidence is being taken from that room, it has to be noted somewhere. So that chain must be maintained in terms of preserving that evidence. So you must make sure that the chain of custody is maintained. Now, when you talk about evidence management, I've just given you that the diagram that I put there. You can see that we have, first of all, the procedures are down there. The procedure to protect evidence and document when collecting and shipping that evidence. You must have a logbook of the project, that is of the evidence, so that everything that is done against that evidence is logged. You must have a tag that uniquely identify any evidence. Remember, the evidence, for if it's a hard disk, it has got serial number, it has got the manufacturer. These are things that are uniquely identifying that particular evidence. Then you have to have the chain of custody record. When there is a need to transfer that evidence from one station to the other, then you need also to have that in place. At the time of the evidence transfer, both the sender and receiver need to give information about date, time of the transfer, and the chain of custody record. Because date and time is very important. Date and time stamp is very important. I told you that in my last case, which I had, which was the date was a problem, and that tilted the case towards our favor. Now, documentation, this is achieved by proper handling and documentation of the evidence. And then when it comes to protection, evidence management helps in protecting the true temperament of the evidence. So this chain of custody, what is it? It is a chronological documentation or paper trail showing the seizure, the custody, the control, the transfer, analysis, and disposition of evidence, of electronic evidence. To maintain the chain of custody, you must preserve the evidence from the time it is collected to the time it is taken to court. Now, the forensic investigator will be able to testify that the evidence offered in court is the same evidence that was collected or received. They also must testify that to the time and date the evidence was received or transferred to another agency. They also need to testify that there was no tampering with the item while it was in custody. So a chain of custody should be initiated at the time the evidence is recovered, and it begins as soon as the seizure takes place and concludes when the evidence is actually destroyed. So you can see the chain of custody is a legal document. That is why when it comes to court, you need to prove that the chain of custody has not been broken. It's a legal document that demonstrates that the progression of evidence as it travels from the original evidence location to the forensic laboratory, eventually to the time of presenting in the court. So what are the functions of this? It governs the collection, handling, storage, testing, and disposition of evidence. It safeguards against the tampering with or substitution of evidence, and documents that these steps have been carried out. Now, the chain of custody form should have some things like description, the type, depending on the organization or that doing the investigation, you can put as much information as possible on the chain of custody so that these people can be able to understand what you collected. That is just a sample chain of custody form. You can see I put there case number, client reference, reference item, description. So it depends. It depends, but it is important to capture each and every information for the evidence on the chain of custody form. Now, after that, you have, we go to an analysis. You have to analyze that evidence in the laboratory. And to analyze that evidence, this phase requires that the use of appropriate digital tools, digital forensic tools, and methods to uncover the digital data that you are looking for. So it is a phase, and this is where now you involve the use of tools now to uncover the digital data that you are looking for. Now, the type of digital forensic tools vary depending on the type of digital forensic investigation which is being conducted. And this is why I told you that when you are doing forensic investigation on a mobile phone, it is not the same way, the same process of doing forensic analysis on a computer. Then you need to conduct an examination on original evidence. Conducting examination on the original media should be avoided as much as possible, and so that you only use the copy to conduct analysis. Now, the standards and best practices are being followed here, and the main reason that you need to follow the best practices is to establish the validity and reliability of digital forensic results. First of all, for it to be admissible, the tools that are used in the digital forensic process must be scientifically valid. That is, they need to be proven that they provide accurate results through empirical testing. Now, when you look at the link that I put there, that is the NIST link, the National Institute of Science and Technology. You'll see there are various tools, and there's a guideline of which tools to use when you're doing your digital forensic analysis. Now, the digital forensic results must be reliable. That is, the same result must be obtained on different occasions using the same data, tools, and techniques. So if you say we've done our analysis, and then we take that evidence, we give it to another person, they will be able to arrive at the same results using the same data, using the same tools, using the same techniques. That is what we call reliable, the reliable evidence. Now, the result must be repeatable and reproducible. Remember our ACPO principles. Number 3 says that, yes, the other party should be able to pick the evidence, do the same thing, and come up with the same results. So the results are repeatable when the same digital forensic results are obtained using the same test and equipment, laboratory, and operating results. That is when we are talking about repeatable results. However, when we talk about reproducible results, this is when the same digital forensics results are obtained using the same test, but different equipment, laboratory, and operators. Now here, what it's talking about here is that I can use this forensic tool to do my analysis. I'll get the result A. If I need to reproduce that result, then I can use a different equipment, a different laboratory, but the same, I'll come up with the same result. So that is, you have to just note that when you're doing analysis, you need to get the reproducible results or repeatable results. After doing your analysis, then you have to do your reporting. The report should be clear, concise, and written for appropriate audience. Document the scope, the purpose of the examination, give detailed description of the media, document each and every phase which is identified for relevance to the investigation, then provide description of the evidence that was acquired during the investigation. So reporting As I told you, I said earlier, reporting should be written in a clear, non-technical terms, because the audience or your audience are not actually your digital forensic professional. So just make sure that your report is understood. Now, aspects of a good report achieves its purpose by answering the questions that were set in the mandate for the investigator, because I believe when you are called as an investigator, this is what we need you to do. And these are the questions that this report needs to answer, the investigation needs to answer. So your report will actually articulate that. It is also designed to meet the needs of the decision maker. Remember, you are doing this maybe for the court or for the person who hired you. A decision maker may rely on the facts that were presented on the report, and the facts must be based on the evidence or in the file. It must be clear and written in neutral language so that the decision maker and other readers will be able to understand it. You should also be concise and convey the information that is needed. It should be structured in such a way that information can be located easily. So you need to make sure that the results of your investigation will be a report that you are going to hand over that report to the person who engaged you, or if it is you are doing it for prosecution, you need to hand over that report to the investigating officer who hired you to do that job. So it is important that you make sure that your report is clearly understood. Now I'll jump into another presentation. Just a moment. Stop sharing. Just give me a moment. I have the other presentation here. Bear with me, please. Oh, sorry, it's taking time. Yeah, thank you for your patience. So we've looked at the process of digital forensics, and now let's look at some of the challenges and legislation framework. Now the problem here is that admissibility, there's a challenge in terms of admissibility of digital evidence. And there's a time I did an interview with the K24, and the thing was that these guys, they found me when I was doing some testimony in court. And then this case actually flopped. And so they invited me for an interview. And the thing was, why do many cases fail when they go to court? Cases that involve digital forensics or digital evidence, why do they fail? They fail because there are various reasons. Now, you know that electronic evidence is generally fragile and can easily be lose its value when it is not collected, preserved, and guarded in proper and timely manner. And so you find that this is a challenge to many investigators, even though I can tell you that nowadays, I think the DCI, which is cyber unit, which is doing that, we have now very capable people who are doing the investigation. Now, maintaining the integrity of computer-generated evidence is still a challenge to law enforcement, because how do they handle this evidence becomes a problem. If they bring it to court and it can be established that the chain of custody was broken, then you find it casts doubt on that evidence. Then we also have proper procedures needed to be followed to obtain evidence from the defendant's computers in a manner that is legally admissible in court. And law enforcement investigators lack the essential technical training and expertise to effectively collect the evidence, even though this is changing. But when we find, because I think that sometimes we become overwhelmed because we have only one cyber unit in the DCI. So when things happen at the county level, we do not have people who are capable enough to, who have got the technical training and expertise to gather the evidence. Now, lack of legislation, even though this has now, in Kenya, we now have the Computer Crime Act, which is in place, but you find that in many countries, they do not have these legislations. They don't have the proper legislation, because this is because laws were enacted long before the evolution of computers and the internet. So you find that many countries are grappling with this issue of cyber crime and how to collect this evidence, just because, and they do not have the proper laws to take care of this. That is, when you look at, in 2000, there's a guy who was called Onel D. Guzman, who authored the love bug. You can remember that virus, which was called I Love You. Now, this guy, when he was taken to court, there was no legislation in Philippines to prosecute this guy. So you find that this is a big problem, especially in Africa. Many countries are still grappling with the issue of digital evidence and how they can be able to collect that evidence and present it in a way that is really admissible. Now, I start in, there were so many questions about admissibility last time. And I say that, what I said is that admissibility of evidence or the rules of evidence depends on each and every jurisdiction. Now, if you go to the US, you'll have the federal rules of evidence. Now, if we come to Kenya, the most recognized law which we use is Evidence Act. And in the Evidence Act, there are certain sections that you need to look at when you are dealing with the digital evidence. So when you look at the Evidence Act, section 65, subsection 8, you'll find that it deals with a computer printout or a statement in evidence that must be accompanied by a certificate which is supposed to identify a document containing a printout or statement and describing the manner in which it was produced. So when you are looking at computer printout, what it says, this section is saying is just dealing with the computer printouts. So the computer printout, that something that you print on the computer will be admissible as evidence, provided there are certain conditions are followed, and so that when you bring it to court, then the court will ask, will try to test this condition to see whether they are followed. So this certificate, it needs certificate, as you can see. The certificate is, the role of certificate here is to identify the document containing a printout and statement and describing the manner in which it was produced. So if you bring that evidence and you cannot convince the court, you cannot tell the court how you got that evidence, then it does not meet this criteria. The certificate should also be giving such particular of any device involved in the production of that document as may be appropriate for the purpose of showing that the document was produced by a computer. So that must be able to, that must come out very well on that certificate. And this is the problem that we have with both the investigators as well as maybe the prosecution. Because when you bring something to court and this certificate is not there, or this certificate is not giving the proper information as to what the court can rely on to make a decision, then it becomes difficult for that evidence to be admitted in the court of law. So you need to look at section 65, subsection 8, which has got this information that that you need as a investigator. Now, the other section is on section 78A. Now, somebody asked about SMS, WhatsApp, all those things that you get from digital devices apart from the computer printout. Now, that is taken care of in section 78A. And what does it say? The Act recognizes and endorses the use of electronic evidence, reiterates the condition for the admissibility of the electronic evidence. In any legal proceeding, electronic messages and digital material shall be admissible as evidence. So you can see it deals with electronic messages. So if it is WhatsApp, whatever, you must have to, it will be dealt with on the using the section 78A. Now, this is how this is section 78A must be read with another section 106B, subsection 4. So it deals with electronic evidence. However, you cannot just bring a WhatsApp in court and say that, yes, this is the WhatsApp, this has been, that is the evidence. You have to follow the digital forensics process to extract that data and report it in a way that is going to be admissible in court. Now, and that procedure, if it is not followed, then it will be able to, information or that digital evidence will not be acceptable. So the court shall not deny admissibility of digital evidence under only on the ground that it is not in its original form. The weight attached to electronic evidence and digital evidence is determined by the reliability on how it was generated, stored, and communicated, on how it was preserved, on the originator was identified, and how the other relevant factors. So it is important, yes, when the determination is going to be done by the court, if it is electronic messages, WhatsApp, SMS, whatever, they'll follow the section 78A. And this section 78A will be read with section 106B. Just get that properly. Now, when we talk about section 106B, we're talking about electronic records now. They are conditioned to certify the court. The electronic record was produced, fed into, or derived from the computer in an ordinary course of business by a person having lawful control over the computer. And the computer was operating properly, or if there was in any way in which it was not operating properly, then such malfunction was not of such nature as to affect the electronic record or accuracy of the content. So when your certificate must be able to identify all this. What was the condition of the computer when it was running? Was it properly functioning properly? That must come out of your report. What is the make of this computer, the model, the serial number, blah, blah, all that must come out of your computer or your certificate. So there must be a certificate signed by a person occupying a responsible position in relation to operation of the relevant device or manager of the relevant activity. So that is section 106B. And it is 106B subsection 4. Just get that so that you can go back and look at the Evidence Act. So when we talk about electronic evidence, we are dealing with 3 sections of the Act, the section 65, 65.8, which is talking about computer printout. We talk about section 78A, which is talking about the messages, WhatsApp, SMS, and then that section 78A must be read together with section 106B, which is talking about certificate. So whatever you are bringing to court, first you'll have the mobile phone. There will be the mobile phone serial number, the operating system, the MAC, all that, and then the process of acquiring. How did you acquire that data from the mobile phone? You must have used mobile phone forensics to do that. You need that need to come out very clearly. Now, if maybe if it is maybe a photo that was taken using a mobile phone, then there should be some. We talked about metadata, data about data. So if it's a photo, that photo will have the GPS codes, which will show where the longitude and latitude where that particular photo was taken. So that must come out very clear. And the process of taking that, transferring that photo from the mobile phone to the computer, all this must come out. So the functions of the certificate is to identify the electronic record containing the statement and describing the manner in which it was produced. Then giving such particular of any device involved in the production of that electronic record as may be appropriate for the purposes of showing that the electronic record was produced by the computer. And it's also will be dealing with any matters in which conditions mentioned above, and purporting to be signed by the person occupying the responsible position in relation to the operation of the relevant device or the management of the relevant activity. So it is important as lawyers to know these sections of the Evidence Act, because it is now technically mandatory that when you are bringing any digital evidence in court of law, you must have that certificate. The law does not prescribe the format of the certificate, but it can be in form of a report that just says that, yes, the process that we used to this evidence was, and also it could be maybe in form of affidavit showing that, yes, you swear this affidavit that you are the person who conducted the investigation. Now, let's look at case laws. We have the electronic evidence authentication. This was a case in Republic versus Mark Lloyd Stevenson in 2016. The High Court ruled that the email in question and the attached document were properly excluded from the evidence by the magistrates as they were not properly authenticated. Last week, we talked about the authentication of emails, and I think I showed you one example how we did, how I did one authentication to show that the mail came from this person to this person and cannot be disputed because you can see the relation. Then we, in this case, it will then be appropriate for the expert to lay foundation by authentication, the emails through email's technological footprint. The authentication is required for where any real evidence is being adduced in trial. Then last week also we looked at Razanga, where the witness testimony was backed by a CD that was said to carry a video clip and had been captured by his Nokia phone. It contained the footage of an election clerk with marked ballot papers preparing to stuff them in a ballot box. The clip had been transferred from the phone to the disk. Now, you remember what we talked about in certificate. It was, what was the process of transferring this clip from the phone to the disk? That must come out very clear. The witness, being the owner of the phone, but said nothing about its condition, or whether it was working properly, whether it was functioning properly. It was not there. No evidence regarding the computer used to create the CD. How was the CD created? What was the condition or reliability of that computers? No evidence to show that the one is the one who owned and operated the computer. Then the condition of any device used in the process of the creating it, and a signature from the person who was legally in possession of that gadget. It was not provided. So this was the verdict of Justice Michelule. He said that the person who had copied the clip from the phone to the computer had not created such a certificate to make a CD acceptable. The reason for the particulars of computers used in the production of the CD had to be given, and such particular would in any way make things like the serial number, so that if it comes necessary, one can trace the devices for audit purposes. It also reiterates the ACPO principle number 3, which is that when this happens, then the third party can be able to use the same, take the same evidence and run the same process and produce repeatable evidence. Now, this case last week I mentioned the Republic versus Wilfred Machage and others. Somebody asked about this question, this case, and I think it is somewhere in the database. You can find it. Now, the charge was related to words which are uttered by the accused at a political rally in June 9, 2010. Now, the journalist who had transferred the footage to a Mac computer at K24 edited it and used it to run news that evening. Now, the K24 management authorized the footage and the news stories to be released to investigators who ultimately produced that in the court of law. Now, the electronic evidence that the prosecution intended to rely on was not made by the journalist. So it had been extracted and edited in his absence. So when you talk about the integrity of the evidence, you remember, here is the person who did the video footage. But here you find that the management of K24 allows the investigators to take this video to court as an evidence. However, the person who did it was left out. And the other thing is that the footage was edited. So since the maker of the record was not called as a witness, it was held that the footage was produced was hearsay evidence. So it was not taken as the main evidence. So that's why some of these cases fall. So the case fell because it was not taken as the original evidence. The prosecution failed to show a certificate signed by the person who had direct control of the device that was used to generate the digital evidence. Now, this is similar to a case that I told you last year I had, where prosecution has brought the report, and they've mentioned in the report that yes, we used this device to to create the evidence, but that particular device is not there in court. It was taken again by the court. So you find that the person who did this investigation, who had the control over the device, cannot testify. Now, the content of the electronic recording had not been proved in accordance with the Evidence Act, and the video footage was therefore not admissible in evidence. This evidence was crucial, and its omission was fatal to the prosecution's case. All three were found not guilty and acquitted, just because of the way the thing was handled. So it is important as lawyers to really know these things, so that you know exactly when you go to court what needs to be done and not what needs not to be done. The last case is the Julius Macau Malombe and two others. Now here is a case where I think it was an election petition, and what the judge said is that no certificate was produced showing compliance with the authentication and the required section 106B of the Evidence Act. It was held that the certificate is required for the purposes of reliability, authentication, and integrity of evidence in terms of disclosing the source of the material, how the material was handled, and how the report was generated. So it's still talking about the evidence. So the certificate must uniquely identify the original electronic record, describe the manner of its creation, and describe the particulars of the evidence that created it, and certify compliance with the section 106B. So you can see from all these cases that it is important to know how to handle digital evidence, and the process of making sure that you have proper digital evidence is that you follow the proper procedures of digital forensics. Once you follow those procedures, you can be able to evidently show the court that yes, these are the procedures that are followed. These are the tools that we use to extract the evidence. The tools are properly validated. Then nothing will make that evidence not go through. But if there's a way, if it is prosecution, if there's a way we can be able to poke holes on the process, then you'll find that most of these cases will fail. And many of them have failed. Like all these three cases, you see, they are involving digital evidence, but they have failed because of the manner in which the digital was handled from the start to the time it was brought to court. So there were a lot of loopholes, and this makes these cases to fail. So you as a lawyer, you don't want your case to fail. You just need to make sure that things are done properly. You call people like us who will be able to help you with the investigation and make sure that whatever you bring to court will be tight, will make the case very tight. And at the same time, if you are on the defense side and a case has been brought to you and the report has been, you've been served with a report, and the court tells you that, yeah, please get your expert to look at the report so that they can counter the report. I will also be able to do that. And once I've done that, I'll be able to come to court, give my testimony in the court, and see how we can work together and tilt the report, any report, towards your favor. Thank you so much. I think that is the end of my my presentation, and I think I'll hand it over to Barbara to continue with the moderation of questions. Barbara, back to you.
All right, Lawrence, thank you. Thank you so much for that wonderful presentation. Were it that we were doing a physical session, that is perhaps the one where I would have had to give you that Nyayo clap for a job well done. But nonetheless, receive our appreciation for the presentation. It is really well detailed, so enlightening. I can see even Jonas Nyangweso is agreeing that that was a wonderful presentation, and we have learned so much from it. I think I've seen the CEO of the East African Law Society, Huntington Amal. Would you just want to say something? Because I think when we started, we didn't start with you. So if you're still with us, you could say something.
Good evening, Chairman. I'm amongst the delegates I've been following, and I prefer to keep it that way. Thank you so much, Mr. Chairman Eric and your team, and the East African Law Society team, David Sigano and Barbara, for a well-arranged presentation and lecture. And I also appreciate Lawrence for the good work. Thank you so much.
Karibu Bwana CEO, we appreciate this partnership. It was nice to see you, and of course, even though you would want to be behind the scenes, we have to recognize you because of this partnership that we are working on. And thank you so much for joining us. We have a few questions. I think, Lawrence, your presentation was so good that we did not have any questions, or it was so complex that we did not understand it. I can see there's a question from Jackson Kamenju, and he is asking, how do you balance the dictates of Article 159D, that is on avoiding technicalities, vis-a-vis the strict requirement of the Evidence Act in regards to digital evidence?
Just come again on that question, please. I didn't get it.
Sorry, yes. So he's saying, how do you balance the dictates of Article 159D of the Constitution? That is the one that talks about justice should be administered without undue regard to technicalities, vis-a-vis the strict requirements of the Evidence Act, and I would want to imagine these are those requirements of the certificate and the other factors that the court looks into with regards to digital evidence. I think he's asking a question here that perhaps may lose us from what the essence of his question. But he's basically saying, like, for example, service is to be effected through WhatsApp, service of court pleadings. So if it is done through WhatsApp and that service is disputed, would the person who served the process through WhatsApp be required to attach a digital certificate to prove service? I can see Teresia Memia is asking, how does one generate a certificate? Noah Okidia is asking, is there a framework for admissibility in place at the moment, especially in techno-legal issues? Emmanuel Busu is asking, do we have a prescribed form of the certificate of authentication? So is there a prescribed form of the certificate of authentication? Atisha is asking, is saying that he is an investigative journalism and some of my work is sensitive. What is your comment on using the, is it a TOR browser? Yes, it's a TOR browser to send information over digitally. Is it secure enough? So Lawrence, I would perhaps propose we take those, then I will go into the chat section and pick a few of the questions, and then we can take another round of about 4 or 5 questions.
Okay, thank you, Chairman. Now I'll start with the question regarding certificate. One asked, how do you generate certificate? And the other one asked, is there any preserved or prescribed format? Now, what happens is that the law does not prescribe any format of that certificate. I think if you look at that, there's a case between Kisumu County Government and the Kisumu County Service Board, which were, this is where it was, the court determined that there is no prescribed format of this certificate, and the law does not provide either in terms of any format. So what happens that the certificate can be in form of a report that you've done, and in this report you are declaring that the whatever you put in terms of the digital process that digital forensic process that you've gone through is valid and authentic. The devices that you put there, you properly the serial numbers, the model, and you give all those details. Or it can come in form of a sworn affidavit, where you swear affidavit that yes, whatever I've done is proper, and the due process was followed to come to this report. So the answer is there is no prescribed report. The only thing is that the person who is doing that report, that report should be the person who actually had the authority to use that particular device when doing the investigation, and it was actually the owner, not really the owner, but was in the authoritative position of when was handling that device to do the investigation. So yeah, so that is how you generate a certificate. If I was doing investigation using my laptop, then I'll be able to generate the certificate myself, and I'll sign that certificate. In the certificate, I'll say that I'm using here. I'm using an HP laptop. This is serial number, and at the time I was using this laptop to do investigation, it was in proper working condition. Now, the other question is on the balance between 159 Constitutional Article 159B and the Evidence Act. Now, you see, the Evidence Act prescribe this as the procedure and the technical procedure that must be applied when you are dealing with digital evidence. So it is mandatory on the Evidence Act. So I think it overrides the Article 159B on that aspect, because we'll use the Evidence Act, Section 65, Section 78, and Section 106 when we are dealing with digital evidence. So it is a mandatory, and it is a technical procedure that must be complied for the evidence to be allowed to be accepted in the court of law. Now, the other thing is somebody asked about framework of admissibility in legal cases. Now, still, the framework is just we'll just use the legislation that we'll use is the Evidence Act when we are talking about the digital evidence. Now, when you look at the Evidence Act, it prescribes whatever you bring to court, you have to show that proper procedure was used to get that evidence, to generate that evidence. And there are quite a number of things that have been put there. We looked at those sections, and what it says that provided that proper procedures and process have been followed, and the court can be certified that yes, satisfied that whatever is brought before the court is authentic, then I think that will be enough in terms of the framework. Now, Tor browser, yes, you can use Tor browser. It is secure, except that, you know, Tor, when we talk about Tor means the onion router. What happens is that it is secure in the sense that it was invented with a purpose of making sure that those people who are oppressed, there was no freedom of speech. Places like North Korea, where there's no freedom space. That's why Tor was invented, so that you can actually communicate securely. Because what Tor does is that it takes your message, then it bounces through the servers, different servers, and at each and every server, it peels out the header of the information and puts another header. So what happens is that the only trace that can be there is between the immediate servers, but it will not show you the whole journey of your message as it traverses the internet. It is a secure browser. You can use it, except that you know that Tor is actually used to access the information that is not indexed with the other conventional browser. So information, if we talk about the internet, we know that internet is divided into two. There's the 10% that we normally access through the Google and Internet Explorer, that is indexed information. But the one which is accessed by Tor is an indexed information. It is not indexed. That information is not indexed by the usual conventional browser. So if you're using using Tor, then you also need, there are some things that you have to put in place, because you know you are operating now in the deep web, not the conventional web. However, it is a secure browser that you can use. I think, yeah, I think I've addressed that, the questions.
Yeah, thank you, Lawrence. I think you've addressed all the questions which were asked. I think we have probably another set of 2 or 3 which we can take, and then we'll see if there are no more questions, then we can close the session, because we are about to get into the 2-hour mark. Atish Shah is also asking another question. Are there any softwares that can differentiate deepfakes over original evidence. Eric Kinyua is asking if an organization is using a computer package, say Oracle, but the keying in of data is by an accountant in the organization. Should a party relying on the evidence of a printout have a certificate done by the package management company, that is Oracle? Should the certificate be done by Oracle or the employee, the accountant who is using, who is keying in the data as to the identification and particulars of the device and the correctness of the data? So I think his question is largely touching on the information that then goes into the certificate and who is supposed to give that certificate. Emily is probably looking at all these requirements under section 65, section 78A, 106. And his question is, has any case with digital evidence ever been successfully prosecuted with these difficult standards? Perhaps then this also will answer our concern. Is it that the standards are difficult, or is it that the standards are probably unknown to us as legal practitioners and to most probably also the law enforcement agencies? So I guess as we are looking as to whether they are difficult or not, I may not say they are or not, but perhaps the other question will be whether we really have a good understanding of what is required so that to be able to successfully prosecute a case using digital evidence. We have a question by Robert Mwangi, who is asking, what do you say on the admissibility of mobile phone tracking evidence and how does it affect the right of privacy of the person whose phone or number was tracked? Perhaps tied to this, I may just ask, because I don't know whether this question was asked the last time. Sometimes when a suspect is arrested by police and they confiscate the phone, they would normally ask you to give them your password so that they can investigate those phones. Is it a violation of somebody's rights, or it is something that we should encourage? You know, when you're advising your client and your client is asking you, I've been arrested, they have taken my phone, they have asked me to give them my password. So is that the right way to access that evidence in the phone, or what is the right way to access evidence in a phone of a suspect? Is a suspect required to give his password, and does it amount to quote unquote self-incrimination? I think somebody is still a little bit, this is Thomas Balala would also still want that. There was a question which had been asked on, and this is, I think, a little bit practical for the lawyers. because we are now allowed to serve through email and WhatsApp. And I think maybe that is the reason why this question is coming back again, and you can look at it and address it. So where you serve court documents, pleadings by way of WhatsApp, you will ordinarily just do a certificate of service, and you say that I served using WhatsApp, using my number this to the other person number this, and that that in itself would be enough evidence of service. But suppose the other person disputes that they did not receive your pleadings. I think that is what is causing concern to the lawyers. And the lawyer then, because in the ordinary circumstances, then you would cross-examine the process server in a physical type of setting. You would cross-examine the process server to actually confirm whether process was served or not. But this is WhatsApp, so we are imagining that perhaps the person who will be cross-examined would be the person who swore the affidavit, perhaps the advocate. So then will the person swearing the affidavit be required to produce the certificate, because that is evidence of service by way of WhatsApp? So maybe you can just clarify on that aspect of whether, if there is a dispute of that nature, then the court may require the advocate or the process server to produce a certificate that would be in tandem with the requirements of the Evidence Act to prove service by way of WhatsApp. Lawrence, I can allow you to take those as I look at the last, because quite a bit of comment has come in on the chat. Thank you.
Okay. Yeah, let me start with that one of serving on WhatsApp. I think one thing, there are two things here. Is the certificate of service, which means that when I send it to the person and by WhatsApp, and I can see the blue tick, then I assume that that person has actually read received and read the information. Now, when there is a dispute, now what comes into play here is whether you sent it or not. You see, you will not go take your phone and go and show the judge, tell them that, yes, I served this person, and you can see from the two blue ticks that the person received it. Now it becomes an issue of proving to the court that you sent it. And in proving to the court that you have sent it, there is a device that you are talking about. You are talking about your phone. Now, your phone was working properly. Now, if this happens, then still there's that certificate that is still needed as per section 106B, which says that, yes, this is the phone that I used to send, and this is the time I used to send. You generate that certificate showing all that, and that information, that evidence, has to be extracted from your phone, because your phone becomes now the source of evidence. So when it is extracted to your phone, from your phone, in a manner that is forensically sound, then it has to be accompanied with the certificate. Now the certificate here is the certificate which shows that, which is backing the evidence that you sent it. You see, it's not, and then, so when you're talking to court, you're saying that, yes, I sent it, and it is disputed. However, this is the log or whatever it is, the evidence showing that you sent it, and that evidence will have information like the phone number, the phone, the description of the phone, the model, blah blah, the WhatsApp, version that is running on that phone, and then that evidence is supposed to be accompanied with the certificate as per section 106B. That happens in case there's a dispute. Now, when it comes to police arresting you and telling you to give the password, I think this is something that is getting into privacy. One, that there's where you remember when we were talking about seizure of digital devices, we say that you must have the legal authority to seize that evidence. So if the police has got the legal authority at that time, maybe they have the search warrant, then I think you'll be obliged to give them the password. But if they don't have that, I don't think it is appropriate to give your password without if they don't have that legal authority to search your phone. Now, this goes together with the question that was asked us about the admissibility of mobile phone evidence, which is bordering about your privacy. So I think it is the same thing. Just look at, is there any legal authority to collect that evidence? And if that legal authority is not there, I think it is not wise actually to give that, because that is bordering the privacy. Now, the other question was about cases that have been presented and successfully prosecuted. I don't have any idea of any case that has gone through when with the digital evidence presented in court of law. The ones which I've just given you, you can see they're all flopped, and that is why something is asked: why do they flop? I think the reason why they are flopping is not that the standards are not are difficult. The reason why these things flop is because the guys who are doing this, they don't have prior knowledge of the existence of how this should be presented. There are two aspects here. Digital forensics is a new discipline, and it is a science. So you need to follow procedures and processes to make sure that you get that information or that data from the computer and any other digital media in a scientifically admissible way, of scientifically sound manner, or forensically sound manner. So you find that the problem is that on the training of these people who are actually doing the investigation, lack of the knowledge, and also the lack of training in terms of doing digital forensics investigation. So that contributes a lot, rather than saying that the act is difficult. No, it is not difficult. I think just need to get enlightened on what to do when you are presenting the evidence in the court of law. So when it comes to generation of evidence, we are talking about, here is an accountant who is actually doing the actual work, is the one who is keying the data, is the one who is validating the data, is the one who knows what or how the operation, the software or the Oracle database has been configured. So it is the right person to generate the certificate, not Oracle, because Oracle is not actually using that the data. However, they can liaise with Oracle in terms of some technical aspect. Maybe there are certain configurations that needs to be done so that the data is cleaned properly. So it depends, but the actual person who's supposed to generate that evidence is the person who is actually using the software itself. When it comes to deep fakes and original, yes, when it comes to data, there are software which can be able to detect that deep fakes. Now, what happens here is that I think you've gone to a site, and when you go to a site, you want to download a software. Then beside that, you'll see what we call the hash value. The hash value, when you download that software, and then you take that software through a process, or what we call the mathematical function, to generate the same hash value. Then you compare the hash value that you've generated with what the software, which was with what was put on the website. Then, if they match, you know that this thing is not fake. So there's, I can say yes, there are software out there that can be able to help you differentiate between the deepfakes and original evidence, but they anchor on the integrity process using the hashing algorithm to detect that. But also, I can say it also depends on the situation at hand, when you are in which you are trying to differentiate between deepfakes and the original evidence. Yeah, I think that answers all the questions. Back to you.
There were a few hands which were up. I don't know if the participants still have the questions to ask. David, who had put up his hand? I think I saw a hand or two.
Well, I think the hands have been lowered because they were up at some point.
All right.
Yes, the questions have been answered.
All right, because I also can't see any hands.
Mr. Chairman, I think then you can proceed to close the session.
Yes, you don't have any remarks to make?
Well, mine will be to thank everyone. I think we've had people who have stayed with us. More than 100 people have stayed with us from the beginning till now. It just shows that the session was really good, and no one was willing to leave the session. I would like to thank you and the branch, the Secretariat, for the good work and for ensuring that we have all the attendance and all the communication that related to this session. And also to thank Lawrence. I think the presentation, like the first one, was also great, and people really enjoyed. We will be sharing the presentations to your emails. Even those who missed the last presentation, we've received your emails. I've noted them down, so I'll be sharing them from my address, maybe tomorrow or the day after tomorrow, but be sure they will be sent to you. We also have our YouTube channel, the East Africa Law Society YouTube channel. If you missed something or you've missed any of our past webinars, you can get that there. I think I shared it last time. I will also be sharing the same with you. So thank you, everyone. Thank you all. Have a nice evening. Mr. Chairman, please close for us.
All right. Thank you, David. Lawrence, we owe you a deep debt of gratitude. We are grateful for you sharing your experience and the information that you've given us. It's been quite insightful. I do note that there are one or two people who had posed some questions and they feel that those questions perhaps have not been answered, but we still have a last session that is coming up on Thursday. We will go through the chat section, the question and answer section, so that if there's any question which may not have been answered because of time, we were scheduled to do this for 2 hours. We are now going to nearly 2.5 hours, and we would also want to release people so that they can attend to the other functions. So any question that may not have been answered, we'll look into it, and then it can be answered in our subsequent section. So thank you everyone for joining. I want to thank everyone for staying with us up to the end of it. It is quite satisfying to see that at around 5, close going to 5:30, we still have about 100 participants in the webinar. It makes us feel like we are offering you the content that you deserve. And with that, Lawrence, again, thank you. We see you next Thursday for another, for the last series of this. But of course, given the level of interest, it looks like Lawrence would be looking for you again to give out this very, very insightful presentation, or for us to look into the other areas relating to digital forensics that we may not have covered in this 3-part series. So I want to thank you. Have a nice evening, and God bless all of you. Thank you so much.